for those of y'all that know me, I want to introduce my wife.
Yeah,
Stay away from
it's
that.
like a high
Okay,
heat.
yeah.
Stay off to the side.
Stay over here.
Yeah, this is my wife, Jean Fair. She's principal
Hello.
attorney of Fair Law PLC, the firm that she and I ran for almost 10 years until I decided to become a teacher again. So she's going to talk today about the Second Amendment and some of the more interesting elements of constitutional carry. So have fun with it.
So, yeah, so in Texas, guns, everyone's favorite subject. So, all right, here we go. So to start off with, let's take a look at just the Second Amendment itself. You hear a lot of debate about the Second Amendment, people arguing about it back and forth, whatever side of the debate you're on, there's a lot of arguments about it, but if you look at the actual text of the Second Amendment, there's not a whole lot to it. That's it. That's all it is. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's all it says. You won't find anything else more in the Constitution about the right to keep and bear arms. Really, that's it. And the problem with that is what we like to call statutory interpretation in the legal field, which is basically, okay, so the legislature has written this thing that is now our law, so what exactly does it mean? And we have to deal with that a lot here in Texas. I make fun of the Texas legislature a lot for the way they write their laws, but here's kind of one of the earlier iterations of, okay, well, we have this law, now what do we do with it? Especially now, the argument is today, does the Second Amendment even mean the same thing that it did at the time it was written? I'll get into it a little bit later when we talk about some of the cases on it, but you have the problem with this word militia appearing in there, so is it only referring to the right of the people to keep and bear arms in service of protecting their state? Is it protecting the right of individuals to keep and bear arms themselves? What on earth does it mean? And I like to poke fun at the Second Amendment a little bit because it doesn't really help that even by our standards of English today and looking back on older forms of the English language, it really wasn't that well written. Just from a grammatical standpoint, it wasn't that well written. That doesn't help with the interpretation of the Second Amendment at all. So as much as we like our founding fathers and as geniuses as they were, this is the one thing they let slip by. They could have improved the language of the Second Amendment a little bit. So there you are. You laugh, but this is inherently the problem with the Second Amendment. So just as a sort of fun exercise, I rewrote the Second Amendment a couple of different ways, and if you look at how you change the language, we get different results maybe for what does the Second Amendment still mean to us. So first I tried to keep the spirit of what the Founding Fathers wrote and just sort of improve the language grammatically a little bit. And maybe now if it said, because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Grammatically, it makes more sense. You're not wondering, okay, now what exactly is the subject and the predicate of this sentence that I can't even follow, but you're still left with the problem of, well, what does that word militia mean, and what does that mean for individuals? So let's skip down to our second example. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms when serving in the militia shall not be infringed. That one would probably yield a vastly different result than what we've got as far as our Second Amendment rights that we now know today. That one is a little more clear about, well, you have the right to keep and bear arms when you're serving in the militia. That, from the plain meaning of what you would think that text means, almost specifically excludes individual rights to carry. Now, how about that third one? A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms in defense of himself or the state shall not be infringed. Okay, now you're looking like, okay, now it looks like individual rights to keep and bear arms were contemplated by that. So let's take it one step further. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms on their person shall not be infringed. That one That one I like to think we had that one, we have trouble even regulating, like we had up until recently when we got constitutional carry, even the licensing to carry handguns on ourselves. That one almost makes it seem like, well, being able to carry your firearms on your person whenever, wherever you want is what the Founding Fathers intended, if that had been the language. We good?
Yeah. It does that.
Okay. Wanted to make sure that I didn't do anything there. Okay. And the last one, and then we'll move on, and I'll stop being the language nerd that I am. So, a well-regulated militia being necessary to the security of the free state, the right of the people to keep and bear arms in their homes shall not be infringed. Well, that would probably leave us with where we've probably heard a lot of arguments on Second Amendment rights, is that, yeah, keeping firearms in your homes is fine, but let's not let people just carry them around. If that had been the Founding Fathers' intent, and that's what they've written, that might be where we are now. But no, that's not what we've got. We're left with that one and trying to figure out what that means. Now, as much as I ragged on the Texas Constitution just a little while ago, in this one case, the Texas Constitution actually did it better. Here's what the Texas Constitution has to say about Second Amendment rights. And that came out as Section 21. That should be Section 23. So I apologize for that. Section 23 in Article 1. Under the big all-capital heading, right to keep and bear arms. That is how it's written in our Texas Constitution, under that big capitalized heading. So every citizen shall have the right to keep and bear arms in lawful defense of himself or the state. But the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime. A little more easy to digest, a little easier to understand about where our rights lay as far as serving in the military versus individual rights to keep arms. So in this one instance, good job, Texas, good job.
Was this changed in the last session?
No.
Okay, this is the 76
Yeah, this is still the language from the 76 Constitution.
It's good language at the time.
I know. Especially as compared to what we got in the federal Constitution.
Yeah.
But anyway, that leads us to the first case we're going to talk about. This is actually the first instance that came before the United States Supreme Court where we actually saw what might have been a violation of Second Amendment rights. And United States v. I'm just going to say Crookshank because I'm not even going to try to pronounce that. But anyway, this was a case that came out of Reconstruction after the Civil War. So we already know that it's going to be a mess. But anyway, shortly after Reconstruction, there was this law called the Enforcement Act of 1870 that was put into place by the federal government. And basically it said that two or more people could not conspire to limit the civil rights and individual liberties of any other person. Basically, it was aimed at the old racists and slaveholders in the South who were none too happy about the 13th Amendment now being put into place and the 14th Amendment making that applicable to the states and allowing the newly freed African Americans to exercise their rights that we all had under the Bill of Rights. So that was what the Enforcement Act was aimed at, was you can't do that. So in Crookshank, a bunch of white Southerners were trying to prevent African Americans from peaceably assembling, exercising their First Amendment right, and keeping and bearing arms, Second Amendment right. It ended up in a lot of bloodshed, a lot of killing, and people being charged under this Enforcement Act of 1870. And so the question came up before the Supreme Court. All right, so you have this Enforcement Act, which is a federal law that is regulating how individuals are interfering with the fundamental rights of other individuals in the states. Is that something a federal law should even be doing? So the fact that this applied to the Second Amendment was really ancillary to the bigger question that they were answering in this case. And basically it came out to, well, okay, no. And in this case, the federal government has overstepped its bounds as far as the way we understand federal government versus state right powers to work at this time. So here's some of the language of what they said. sovereignty for the protection of the rights of life and liberty within the respective states rests alone in the states. Basically, that's the Supreme Court saying, okay, the federal government, when the founding fathers put this country together, we very specifically laid out, here's what the federal government can do, everything else is a state power. And dealing with the individual liberties of individuals, not stopping the federal government from interfering with you, but as far as individuals on individuals, that's for the states to deal with because it wasn't given to the federal government. So this Enforcement Act, which is what this is trying to do, which is to stop individuals from interfering with the civil rights of other individuals, is a state problem. You have to look to your individual states to do this. That's not a federal government issue. And so even though, yes, we do have the 14th Amendment, which makes federal law applicable to the states to the effect that it cannot allow the states to interfere with individual liberties, it's still up to the states to manage individual on individual interferences of liberties and rights. And so we were left with kind of this weird limbo on the Second Amendment of, well, okay, does it apply to state action? Does it apply to only federal action? And that's really all you got as far as Second Amendment in the Supreme Court for a very long time. Because of what that case said about how it's really just kind of up to the states to manage what individuals and the states themselves do with your civil liberties, then that's why we didn't see the Second Amendment come up again really before the Supreme Court until 2008. So yes, all the way from 1875 to 2008, we didn't really get an important Second Amendment case before the United States Supreme Court. And so it took us all the way until 2008 with the District of Columbia versus Heller. Thank God, a name I can pronounce. So the way this came about was the District of Columbia, Washington, D.C., had part of their statutes in their code that made it illegal to carry unregistered firearms. And you couldn't register handguns at all. So basically handguns were completely out in D.C. Although the chief of police could issue you a 1-year license for handguns, but you had to get the chief of police approval, he had to approve it, it was a process. And if you did have a firearm that was not one of these handguns and you were registered, you had to keep it unloaded and disassembled or bound with a trigger lock unless you were actively using it for legal recreational purposes, basically hunting. So
DC was very similar to what California is now.
Yes.
With their current regulations.
So yeah, basically your guns in DC were useless. You couldn't do anything with them. So this case came about when a police officer named Dick Anthony Heller in DC applied for one of these 1-year permits to keep a handgun, which he used on duty in his home and was denied. So Heller sued the District of Columbia. It went up the chain through the district court and the appellate courts and eventually landed in front of the Supreme Court, who now had to ask the question, okay, does the Second Amendment protect individual rights to keep and bear arms, or is it limited to militia, aka military service? We've never really addressed this question yet, so here it is, now is the time. And so essentially what they held is, okay, yes, that first part of the Second Amendment, that part referencing the militia, they said that's what they call prefatory in nature. Basically, it's a preface. It's just sort of an introduction to the meat and the important part of the amendment, which is the right to keep and bear arms shall not be infringed. And they said the term militia shouldn't be limited to mean those serving in the military, because at the time the amendment was written, and if you go into law school or pay attention to anything involving law, you will always hear, when you interpret statute, you want to look at the plain meaning of the text at the time it was written. So basically pay attention to what would this have meant when it was written. So that's what the court tried to do here, is look at what would the word militia have meant when it was written. And they came to, well, that meant not only those serving in the military, but also any able-bodied man, or now we would say any able-bodied person capable of being called into service. And you cannot be a ready and well-regulated militia if you can't have your arms on you when you're not actually in that service. And they also said the reading of the Second Amendment is limiting the right to bear arms to only those actually involved in government military force would create exactly the type of state-sponsored military force that the Second Amendment, when it was written, was there to protect against. Because remember, we got our Bill of Rights shortly after we got our Constitution, and that came on the heels of the Revolutionary War, which came on the heels of, we're tired of Britain sending their people over here to basically do with us as they see fit, and they're telling us that we can't have our own weapons to fight against them because what we think they're doing is wrong. So that's where that interpretation came from. And again, this was saying, yeah, we're taking, the legal writing of the time and scholarship on the issue, which all said that at the time, the term militia was understood to mean not just people actively serving in support of your state or in the military, but anybody who could be called to serve at the time. So, landmark case for the Second Amendment, yes, despite the word militia, the right to keep and bear arms is an individual right. We do have the right to keep and bear arms. And that decision in Heller led us to McDonald versus the city of Chicago. Basically, very similar to the Heller case, just now, okay, so Heller told us that the Second Amendment does protect our right to keep and bear arms from infringement by the federal government. But now what about state governments? Because we have that pesky Cruikshank case that said, well, yeah, the Second Amendment is, it protects infringement from the federal government, but as far as your rights in the states, that's a state thing, hands off. So now that issue's coming up again. Because we got Heller saying, yep, individual rights, they're good under the Second Amendment. And so you had cities like Chicago who had gun bans very similar to those in DC, and so McDonald versus City of Chicago was a culmination of several suits now that popped up saying, all right, well, we've got the Heller case, look, it is an individual right, so does that apply now to the states because of the 14th Amendment, or does it not? And so basically we came up to, okay, yes, we were wrong in Cruikshank, we should have applied the Second Amendment to the states through the 14th Amendment, and if you don't know what the 14th Amendment is, that's what we call the Due Process Clause. Basically it's saying anything that the federal government is prohibited from doing to limit your rights at the federal level, states have to follow suit. They can't do that either.
Guys, in my class, you should know that. We talked about that this week, remember? And you remember why Chicago was so bad?
Basically, yeah, it was crime, yeah.
Yeah, no, but the idea of why they were restricting so much. We had a client one time that said he went to a Chicago airport with a gun.
Oh, that's right, yeah, and they wouldn't even let him get it off his...
No, they literally had cops sitting
there in case he picked up his bag that his
gun, and they were going to arrest him.
Checked in, yeah.
That's how bad Chicago was. Yeah.
But yeah.
So that's what Chicago was targeting.
Crazy, yeah. But yeah, Chicago was crazy. It was if you had a handgun on your person, like at all, in any capacity, no go.
Yeah, especially the bag at the airport.
Yeah. Yeah, and this was a bag that was checked that he just picked up, not even a carry-on bag, just one that was checked. You had to go pick it up off the stupid little carousel where you're waiting forever and ever, and the bags are starting to dwindle, and you're thinking, great, did they lose my bag? Yeah, it was one of those.
Yeah, and there's a plainclothes cop literally sitting there waiting for you to pick up that bag, because they already scanned that bag and knew it had a gun in there. As soon as you picked it up, you're guilty of a felony. That's entrapment. In any other state, that's entrapment. But, Illinois plays rules a little differently.
Yeah.
Fast.
But yeah, so basically, yeah, this came back and said, yeah, okay, yeah, Cruikshank was wrong, and ironically, not too long after the Cruikshank case came out, there was a line of cases that slowly started incorporating other parts of the Bill of Rights to the states through the 14th Amendment, throwing like the First Amendment in there, and the Fourth, and the Fifth, and now eventually in 2010 they get to the Second Amendment and say, yeah, okay, that should have been applied, all the way back when. But here's what they said about it, was that rights that are, quote, fundamental to the nation's scheme of ordered liberty, or that are, quote, deeply rooted in this nation's history and tradition, are appropriately applied to the states through the 14th Amendment. Well, we've already got Heller that has said, yes, the individual, not just military service, individual right to keep and bear arms is one of those fundamental and deeply rooted rights. So, yeah, once Heller came out, they really had nowhere to go on McDonald, and yes, of course, the Second Amendment applies through the 14th Amendment. All right, and that brings us to constitutional carry, which, if you haven't been paying attention to Texas news, basically, as of earlier this month, as of September 1st, what we're calling constitutional carry in Texas came into effect. So basically, you can carry a handgun on your person, license or no. And so we'll get to unlawful possession of a firearm in a minute, but yeah, here's what they say about it in sort of the preamble to.
Oh, is this the part where they recognize Heller, the legislature recognized?
No, where they don't recognize Heller, where they should have.
Oh, okay.
But yeah, here's what it says. So yeah, the legislature of the state of Texas finds that the Second Amendment of the United States protects an individual right to keep and bear arms and to possess a firearm unconnected with the service in militia, and to use the firearm for traditionally lawful purposes such as self-defense within the home. All of this is stuff that came out of Heller, but what gets me is that they said, well, where did it go? The legislature of the state of Texas finds all of this. The legislature of the state of Texas didn't do any of that. Okay, that's not the legislature's job. If you go back to Schoolhouse Rock and talking about the three branches of the government, it's not the legislature's job to interpret the laws. That's the judicial branch's job. That's what the Supreme Court did in Heller. They're the ones that found that the Second Amendment protects the individual right to keep and bear arms unconnected with militia service. So what you should have done, Texas, is just to say, okay, in light of decisions like Heller, we're recognizing that, yes, it's an individual right to keep and bear arms, so there you go. But sloppy writing from the Texas legislature, like I said, I like to pick on them because I'm a language nerd and I have nothing better to do with my time.
And you guys think I'm bad.
But yes, so they find the Second Amendment protects the right, and also our Section 23, Article 1, which is our Texas counterpart to the Second Amendment, secures for the citizens the right to keep and bear arms. All right, fine, I'll let it pass. Yeah, so basically what it's intended to do, anyone who is 21 or older and not otherwise prohibited from carrying a firearm, which is all of this. Yeah, you can carry, license or no. And so it starts off kind of reviewing and streamlining a little bit who is allowed to possess a firearm and who isn't. There's nothing new that was added there. Yeah, as far as our constitutional carry law, nothing new as far as who is prevented from possessing a firearm and who's not. If you're convicted of a felony, you can't have a firearm at all until 5 years after you're either released from prison or released from parole or community supervision, whatever. And after that, you can only have it in your home. Same thing if you're convicted of anything involving family violence. You can't possess a firearm if you're under a protective order from the family code or our code of criminal procedure, or any of that list right there of anyone who under federal law is prohibited from possessing
Anybody
a
who's
firearm.
ever bought a gun that's filled out the ATF form has seen that.
Has
that
seen
stuff right
those,
there.
yeah. Yeah, what gets me is you go to buy a gun and they ask you right there on the form, are you a fugitive from justice, yes or no? And I
Some
just sit
people
there and
have
go,
checked yes.
even if you are, would you check yes?
I heard a story from a gun shop owner one time that somebody actually checked yes, and they're required by federal law to call the FBI. And so this guy, they're just keeping him there in the shop, blah, 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 going along, and he checks, yep, I'm a fugitive from justice. And what happens? FBI comes in, and then they call the local police and say, hey, go pick this guy up from us. And, obviously he's got a social over there, they check him out, and he's got a warrant. And, they pick him up. And he's dumbfounded that this happens. They can't do that. Yeah, they can.
Yeah.
Yeah, absolutely.
Yeah. So you
Absolutely.
understand why he had a warrant for him now. Yeah. You kind of get it after that. But yeah, those questions that they ask, you look at them and you're like, really? Look at people answer those? But apparently they do.
Yet the one I've never heard is somebody actually actively putting they renounced U.S. citizenship on there. But because you get some of the ones that are staunchly opposed one way or another, and then they talk about it right outside the gun shop. And as soon as they're going, oh no, I'm a good U.S. citizen, I'm fine.
Okay, but yeah, so I apologize for the formatting. I had to pull this from the actual bill that was, finally enrolled and adopted as of the first, because all of the online sources for all of this that I usually go to have not updated this yet. They still have all the old versions.
This is bleeding edge law right here.
Yes, so yeah, we're on what, the 17th now? Today's 17th, right?
Today's 17.
Yeah, so yeah, this is bleeding, this is a 16-day-old law we're talking about. Okay, but yeah, so this is really the meat of the constitutional carry thing right here. This is where the stuff comes from. Before September 1st, before 16 days ago, it was unlawful for someone to carry a firearm if they were younger than 21 and were unlicensed. You had to have your license. I called it a CHL because I got mine when it was still a concealed handgun license, and they changed it to LTC, or license to carry, because then they threw open carry in there. And now you can just carry either way you go, but whatever. So the underlying stuff is the new stuff that was added to this section here. And I believe this is section 4602, I believe this is. Yeah.
I got my license back in the day when you had to decide if you were going to have a semi-auto handgun or a six-shooter. They had a distinction back in the day. Yeah, I'm dating myself.
Yeah, but yes, this is section 46.02 of the Penal Code, titled Unlawful Carry of Weapons. So you commit an offense if you knowingly, intentionally, recklessly, all the words they like to throw in there, basically saying you know what you're doing. If you are younger than 21 or have been convicted of an offense under those sections, that's all the stuff we just talked about how you would otherwise be prevented from carrying a firearm, and you're not, on your own property, you're going to or from your own vehicle. So basically, if you're over 21 and not otherwise prohibited from carrying a firearm, you're good to go. And that's just more of the same. Basically, if it's going to be in plain view, make sure it's in a holster. That's really the gist of what this is going to do. If you're going to carry your gun where anybody can see it, put it in a holster.
The big thing they took out.
Yes, that's the one I like, was when we got the open carry laws. The way they wrote it was everything was carried in a shoulder or belt holster. And the shoulder holster, that's the James Bond style, wear it under your coat, and you stick your gun right here in your armpit, basically, in the little holster. But the problem came with the belt word. Because then there were questions on, okay, well, when they say belt holster, do they really mean that it has to be attached to your belt, or is it just one that kind of like clips onto your pants if you're not wearing a belt, and it's just more on your hip? And I always said that this could have been solved so easily if they just said, if it's carried in a holster designed to be worn on the hip or shoulder and is, worn accordingly, or something like that. But like I said, I'm a language nerd. I have nothing better to do than criticize the way the legislature writes their statutes. But they fixed this. There's no shoulder or belt holster. It's just a holster.
That renders my belt useless, because as soon as this came out, the belt I'm wearing right now is a 511 tactical belt that has a strap in there of metal that is made to actually hold a holster. Because I figured if anybody ever got in trouble with it, it would be another lawyer, and it would be something like this real stupid where they're looking at an asinine word like, what does a belt holster mean? But then, see, I still have a problem with this. And my problem is this. On holster, what type of holster are we talking about? Are we talking about the standard Phobos holster that you get over at Academy for like $10? It's just a tiny little piece of foam and plastic? Or are we talking about one that has to have a retention clip like the police have, that you have to press down, and then it goes forward, and then you can get the gun out? There's going to be litigation over that one stupid word. I guarantee you.
Yeah, where I think it's going to be is that as long as it's a actual manufactured holster, that it's going to be cool. Where I think you're going to run into problems where people try to DIY their holsters
I have seen
and
people
just
do
like
that.
sew a pocket into their pants or something and try to claim it's a holster.
I've seen people do that. Yeah.
But yeah, what I was going to say with this, with the striking of the shoulder or belt language, was that ladies, if you want to do like the sexy thigh holster, or even men, if you want to do that too, go for it. Not entirely practical, I don't think, but it's available.
And also keep your receipts for your holsters too, because you never know if you actually get into trouble for that, where you might want to provide where you bought it, because the prosecutor might actually say something and get into that asinine level about it. Some counties, I actually know they would.
Okay, so yeah, here's where it starts applying to campus carry, but yeah, there's one more I wanted to just read that I didn't have a chance to put on the PowerPoint just because I think it's funny, but yeah, so basically if you're going to carry, you can, now the way I thought this was going to go when I first read this, I'll get back on track, I promise in a minute, but the way I thought this was going to go when we first got our constitutional carry was I thought we were going to turn into like, I think it's like Utah and Colorado, where they're weird, where you can open carry without a license, but if you're going to conceal, you do have to have a license.
That's how Colorado and Utah work. It is the idea of constitutional carry is something that is open and notorious, so you have to open carry. But even Washington State's like this, that if you're open carrying, you're constitutionally carrying, but you have to undergo psych evals, all sorts of things to get a concealed carry license. Go figure.
Yeah, which I don't think makes a lot of sense.
No.
But yeah, but I thought that's how we were going to go. But yeah, going back to the text of what we've got here. But yeah, going back to the text of what we've got here. No, you don't have to have a license to conceal. Just if it's going to be visible, it's got to be in a holster. That's it. You got to be 21 or older. You can conceal all you want. If it's going to be visible, put it in a holster. So we're not a weird state. Yes. But yes, before we go on to how it affects campus carry, just a funny one. So yeah, listen to this. A person commits an offense if the person carries a handgun while the person is intoxicated and is not on the person's own property or property under the person's control or on private property with the consent of the owner or inside of or directly en route to a vehicle or watercraft that is owned by the person or directly under your control or with consent of the owner. Basically what that amounts to is if you're going to be drunk and have your gun, do it on your own property.
Yeah. Buy acreage if you want to be drunk and wave around a gun, apparently. That's what the legislature said.
Yeah, that's what the legislature says. You can be drunk and carry your gun. You just have to do it in your own car or on your own property.
English skills are important. So did they change anything with campus carry or anything like that?
They changed where the stuff was located, but the substance of it, no. Yeah, they just changed where the stuff was located. I know I ragged on some of the language here a little bit, but one of the things that I did like that Texas did with this whole constitutional carry thing was they took the opportunity to streamline a lot of our carry laws, because it used to be a mess. It was scattered everywhere. They had sections for non-licensed people and sections for licensed people, and then that was mixed in with the places where weapons were prohibited anyway, regardless, and stuff was scattered everywhere. And then they've kind of streamlined a lot of this stuff now. Like they've completely repealed Penal Code Section 46.035, which was just unlawful carrying by license holders, which was a section just for license holders, which really duplicated a lot of the other sections and then just cross-referenced places where weapons are prohibited anyway, and other statutes which are just general unlawful carry. And like I said, it was a mess, so they fixed that, just got rid of that. And now everything dealing with license holders is just covered by either just the plain unlawful carrying of weapons statute or the plain places where weapons are prohibited anyway statute. Which it should have really been that way in the first place, but they fixed it. So yeah, under section 4603 of the Penal Code, places where weapons are prohibited, here's where it starts kind of applying to campus carry, and here's really one of the only reasons why you would want to have a license to carry anymore, if that's on your radar. So basically, yeah, you commit an offense if you go on the premises of a school. Basically, schools are still out. Constitutional carry didn't change any of that. Schools are still out. You cannot carry on the premises of a school. That word is still there. There's a lot of
meaning in that word.
yes, there's a lot of meaning in that word. That was handled a lot with the open carry laws. But yeah, premises only means buildings. In all of these laws dealing with firearms and weapon carry, when they use that word premises, it means buildings only.
So I can carry it up to the door?
So yeah,
Yeah,
so you can carry it up to the door. Yeah.
You just can't walk beyond the threshold of the door. The threshold of the
Yeah,
door.
premises, it's, I didn't include it in the PowerPoint, but yeah, elsewhere it defines premises, and premises is very clearly that it is only buildings or parts of buildings. It does not include parking lots, sidewalks, walkways. None of that is included in the word premises. But yeah, constitutional carry didn't affect schools and doesn't affect campus carry. The way campus carry had worked in light of the open carry stuff was, yes, you can conceal carry on campus, you cannot open carry on campus. That is still in effect, and it only applies to license holders. So constitutional carry doesn't reach out to campus carry. You still got to be licensed to carry on a college campus, and you still have to do it concealed.
So there's still reasons actually to get an LTC.
There are still reasons. There aren't as many, but there are still reasons. So yes, and like I said, that's all now included under just the places where weapons are prohibited statute, and the rest of it is the same. If you're familiar with our firearm law at all, that list of prohibited places should look very, very familiar to you. Nothing else has changed there. Like I said, the real meat of our constitutional carry law was that one little section I already showed you, where basically as long as you're not otherwise prevented from carrying a firearm and you're 21, you're good. Now, one thing that I thought that the Texas legislature had fixed in this one, but after, me and you did our thing where we talk about it and argue back and forth like lawyers do, they didn't fix
You
it.
wouldn't want to go to dinner with us because all we do is argue back and forth about this stuff.
Yeah.
Especially about the amusement park thing.
Yeah, but yes, that's what I was getting to. The word amusement park. Until this legislative session, until this constitutional carry, they defined the word amusement park. I'll read the definition in a minute, but the debate over the amusement parks was, okay, we'll do like county fairs count as amusement parks. Because they bring in the carnival rides for the county fairs, and they have lots of people there. So do those count as amusement parks for the purpose of the prohibited places? So in light of those questions, our legislature fixed it. You'll see our other issues with this in a minute, but amusement park means a permanent indoor or outdoor facility, so the temporary fairs and carnivals are out, where amusement rides are available for use by the public, that is located in a county with a population of at least 1 million, encompasses at least 75 acres in surface area, is enclosed with access only through controlled entries, is open for more than 120 days in each calendar year, and has security guards on premises at all times. Again, the term does not include any public or private driveway, street, sidewalk, walkway, parking lot, garage, or other parking areas, basically the premises of the amusement park.
You walk through the gates,
Yeah.
you're liable.
So, okay, so amusement park, we think it's fixed, right? You don't have the fair question anymore, because the fairs don't meet the permanent facility aspect or the 120-day aspect anymore.
And that was one of the most litigated aspects of that. Every year you'd have a county fair, you'd have lawsuits come up at the county levels about whether people could go in and carry or not. And that's one of the reasons they closed this loophole.
Yeah, so, okay.
So they did one thing right.
So, okay, the fairs are out, but then, my annoying lawyer brain starts working, and the first thing I think of is, okay, well, I went to the Houston Zoo a lot when I was growing up in Katy, and at the Houston Zoo, they have a carousel there. The zoo is primarily, you go look at the animals, but they have a carousel in the zoo. Well, the carousel is an amusement ride. And if you look at that definition again, the Houston Zoo otherwise meets that definition. Okay, it's a permanent facility, right? amusement ride. It's only one, granted. It's a, it's a carousel, but it's an amusement ride available for the public. The county population is more than 1 million. It's at least 75 acres in surface area, enclosed through controlled entries, open for more than 120 days a year. So does the zoo count as an amusement park? Because you can tell the way this was written, this was clearly written with Six Flags and SeaWorld and Schlitterbahn in mind. But,
Not the Houston Zoo with their one carousel.
but does the Houston Zoo count now?
So it just opens more questions.
So yeah, and then that got me thinking, okay, what else did I do when I was a kid and growing up? Okay, I went to the Natural History Museum a lot. Okay, they don't really have stuff that would be like rides per se, but they do have that planetarium thing. You go in, you sit down, and you look up, and the planetarium thing does this thing. If you get someone like me who has nothing better to do with their time, don't tell me there aren't lawyers out there who couldn't argue that that's a ride for the purpose of this statute.
What about like a public park or somewhere they have children's swings or slides or something like that?
I don't think public parks are good.
Parks.
Yeah, I don't think public parks, because they wouldn't fit the, they wouldn't fit the enclosed with access only through controlled areas element of it.
Now, what's interesting over the years is the whole idea of like city municipal parks. For a while in Waco has Cameron Park, and Cameron Park is like 40 miles of awesome mountain biking trails, walking trails, and stuff like that. There was talk when they did renovations back around 2010 that they were going to put signs up limiting guns from being in the park because it's a city park. That never caught anywhere because I cannot see, based on these restricted locations, how they could fit that in. They would have a very difficult time making that argument. So, yeah, city parks, stuff like that, I don't really see it because, this is it. When you look at, this is the list of prohibited places. And if they're going to try to pigeonhole something in, they've got to make it work with this. Now, okay, let's just go a little further. Within 1,000 feet of the premises is designated as a place of execution. So if there's a city park within 1,000 feet of Huntsville when they're about to kill somebody, you got a problem. See? So sometimes you got to compound these to understand what they're trying to do. But now I don't think city parks.
But yeah, I don't think city parks would do that. But then my other question was, okay, Galveston, Moody Gardens. They have the thing with the little rainforest exhibit. They have the big aquarium, and then sometimes they have things that would count as rides, and sometimes they don't. If you look back at the definition, it just said that the facility had to be permanent, not that the rides had to be permanent. So does Moody Gardens count as an amusement park? And then does it only count as an amusement park when the rides are present, or does it only apply to the section of Moody Gardens where the rides are? So they tried to fix the amusement park thing, but yeah, it's still got issues.
And the big one to take away, I think, for you guys out of this is the 51% signs.
That's unchanged.
That's unchanged. I'm telling you, don't chance it. Especially around here, I've noticed more places are 51% than I've seen like in Central Texas. If you see those signs, the white and red signs, stay away from them if you want to carry. The issue is, this is typically bars, but the issue always comes up because they have to send the state of Texas their tax information about this. And you could literally have a restaurant that's having a bad year because of COVID that turns to selling more alcohol, and they will turn to a 51% overnight because of how their apportionment of food they're selling changes as opposed to alcohol. These things change every month. So you might know a restaurant, but COVID has caused a lot of problems like that. And I've heard of some litigation in the past year because of COVID where people got arrested for violating 51% because they went to the same restaurant they've been going into for years carrying. But because they're selling less food because of COVID, now they're ending up violating that. Yeah. So
yeah, watch for your signs. All right, yeah, before I get on to that, speaking of signs, we have a new sign.
they added a new one.
Oh, there are 2 new signs. Yes, there are 2 new signs. So yeah, if you're familiar with gun law, you know the 30-06 sign, which is prohibiting concealed carry. When open carry came about, they added 30-07, which prevents open carry. Now they have 30-05 for constitutional carry. And it says, basically you have to put up the sign, it says, pursuant to section 30-05 penal code, a person may not enter this property with a firearm. And that's for everybody who isn't a license holder. It still has to follow all the same requirements you're used to. You gotta have the English version and the Spanish version, gotta be contrasty colors, block letters at least 1 inch height, displayed conspicuously at each entrance, clearly visible to the public, all the good stuff you're used to. Same thing, just now it applies to non-license holders. And if all you see is the 30-05 one and you're a license holder, that doesn't apply to you. You still have to have the 30-06 and 30-07s for license holders.
So basically now they have 3 signs.
Oh yes. And I think they missed an opportunity with 30-06. I don't know if anyone caught this when the open carry passed, but open carry had the language about has to be posted at each entrance, and that wasn't included in the 30-06 language. Well, they included it in the 30-05 language, the posted at each entrance language, so I thought, okay, surely they're going to go back and fix this now with 30-06 and just stick those 3 little words there at each entrance. The sign has to be posted at each entrance. No, they didn't.
And there are actually businesses out there I've seen that know this and they abuse that. Buc-ee's is one of them I've seen do this more than any. You'll see the 30-07 at every entrance, but they'll only put the 30-06 on one of them. Some of them know this.
That's besides the point though, but there's a lot of places out there I think that abuse that know that loophole's there.
Mm-hmm. But there I go again ragging on the Texas legislature, but they could have fixed it, but they didn't. And then one more new sign. You have a section 4603 sign, the prohibited places sign. The language there is pursuant to section 46.03 penal code, a person may not carry a firearm or other weapon on this property. Basically that's for places where weapons are prohibited anyway. Now don't get confused and think that sign has to be there for the places to be prohibited. They're still prohibited. It's just a new sign, all the same sign requirements. Except here's where it comes into play. It's a defense to carrying a weapon onto any of those prohibited places if you are then told, hey, you can't carry here, and you leave. But you don't get to use that defense if they had the signage out, or if you already knew that you couldn't carry there anyway. So ignorance is not an excuse.
Oh, so they took that away, so it's almost strict liability if that's...
At least with the prohibited places.
Oh, that's serious right there. That is a big change.
Yes. So that's why they have the prohibited places signage, so they can put it out there. If the signage isn't there, and you're then told, hey, you gotta leave, you can't have a gun here, as long as you don't give them any trouble and you go, you're cool. But they're right there, section Ed, it is not a defense. If the sign prescribed by section O, that's the prohibited places sign I just talked about, was posted prominently at each entrance as applicable, or you knew that carrying a firearm there was prohibited.
This used to be the norm.
You don't get to feign ignorance.
This used to be the norm with 30-06 and 30-07 before they changed it. Oh wow, so they're
Yes.
backtracking. Wow.
Yes. Yeah, so that's the high points of the constitutional carry. I think I probably went over my time a little bit, but
Anybody have
we have
any
a lot to
questions?
go through. Yes.
So, say I'm over 21, I'm a licensed gun carrier, I have registered guns, and dear ATF comes knocking on the door and asks for them. Is that truly constitutional?
At least with that depends on the reason they're there. I want to say that I can't say why they're coming to take your guns away. I don't know if you suddenly become a prohibited person, but assuming you're not one of those prohibited people and everything is otherwise good, it shouldn't be.
Yeah, and just the important thing is never talk to the police.
Yeah.
Because usually they're going to have stuff already on you, and all you're doing is just giving them more information to get a conviction. That's all you're doing.
So if you do ever have a run-in like that, you shut your mouth and say, I will be happy to speak with you after I talk to an attorney.
That's the way to do it. And you know what? the cops get mad, they get irritated about, but the reality
They may
is,
send 2 or 3 different people over to try to get you to talk, tell them all the same thing.
you have to be quiet. And but here's an important case that I'll talk about in a second. Your Fifth Amendment rights say you have to tell every police officer that comes to you and says, "Hey, do you want to talk?" If you invoke your Fifth Amendment right to the first police officer, but another one comes up after that, and you start talking to him, you've waived your right. Does that make sense? So you got to tell every police officer, and the police officers know this, especially detectives. It's part of their investigation procedure. And what they'll do is they'll say, "Okay, well, he didn't talk to Joe over here, so I'm going to get Johnny over here to go talk to him and see if he'll talk." He might have told the first guy, "No, Fifth Amendment privileges," but if he immediately starts talking to that second detective, you waived your right.
Just say the same thing, be consistent.
Be absolutely consistent to every one of them.
So then you legally would not have to talk to the second officer.
No, actually not. But if they come up to you and they say, "Hey, why aren't you talking? Why aren't you?" They'll do stuff like that. Yeah, the intimidation's part of it.
They will. They'll probably try to tell you that you do have to talk to them. No.
You have no reason to. But you've got to be consistent about your Fifth Amendment privilege. You have to be consistent because there's a Supreme Court case about that. So be consistent.
Okay.
Okay. Well, thank you.
Your turn.
Okay.